Hello, everyone. Welcome to our webinar. Today it is the Core 4, which is estate planning with the basic documents that literally everyone should have. And this is a series of webinars. We're going to be covering other topics, more advanced topics, trust planning, other tax topics. We'll talk about that in a bit. Down the road, once the dust settles, we'll talk about what's happening in Washington and legislation that is now proposed that may be passed. We'll be following up with that. And of course, on the elder law side, we have done a series of webinars throughout March called Medicaid Mondays in March, 5 30-minute presentations on the New York State Medicaid program. So if you have interest in that, you can find that on our website as well. I'm Lou Pierro here in Albany, New York. I'd like to introduce my partner, Peter Strauss, in our New York City office. Hello, Peter.
Good day, everyone. Thank you, Lou. And we're going to be talking about things that are changing rapidly, both on the tax side and the elder law side, Medicaid changes. And the message we really want to give to everyone today is the things we're going to be talking about are things that really need to be done before an emergency in your lives occurs. As Lou says on his radio show on Saturday mornings, life happens, and sometimes the happenings are not really good. And this is what today is all about. And we're happy to help you. If we don't cover everything today, give us a call. We're happy to serve.
Peter does appear on our radio show, which is live every Saturday morning at 11 a.m. on WGY Talk Radio. It's also online at WGY.com. And life happens, 11 a.m. every Saturday. We talk about all the things that we need to do to plan, things that we need to know, changes in law, changes in circumstance. How do we get ahead of this, and how do we have a plan in place? Today's program, and these are our attorneys that you see here. It's a growing firm, so our New York City office is growing out. We'll be moving soon to 260 Madison Avenue from our current 488 Madison location. In Albany here, we've taken another suite of offices on the first floor in our building, and our attorney roster continues to grow. So we're very happy about that. And with that, our estate planning, the impact of the pandemic, the Core 4, and the most important thing is not thinking about planning or talking about planning, it's executing the plan. And so we're going to talk about how to get through all of that to that next level where you're ready to sign documents. So the pandemic, Peter, has been something that has changed everyone's life, and you're in Manhattan. The picture there last spring, this time, was a very, very different picture.
It was pretty grim. And, I was still coming to the office occasionally, but both in my neighborhood on the Upper West Side and down here, Midtown near Rockefeller Center, the streets were empty. They were desolate. Stores boarded up. Some of them are now reopening, but there's a lot of vacancies. But I took a cab to see a client this morning, and I have to tell you, the traffic was bad. And it's a sign of life.
Yep.
The numbers here are improving. And I do think we're going to be able to return to a partial normal pretty soon. But, as bad as the pandemic has been, and it's been horrible, there are a couple of positives. And one of the things is the ability to work with you all remotely. Not only are people who still feel comfortable being at home and not coming to a lawyer's attorney's office, but people who have disabilities, people perhaps who have Parkinson's or MS or cerebral palsy or other things that make it physically difficult for them to get to an attorney and haven't been able to do their planning. This whole new online remote ability to conference and look people in the eye has been a miracle, and that's going to stay with us. And it has opened up opportunities for many of our clients for whom we weren't able to serve as intimately and as importantly as we can do now.
So due to the pandemic, New York State has changed its law to allow us to not only do an initial consultation, an initial meeting, but we can actually do the document execution for anyone in New York State virtually now, 100% virtual. The notary, the witnesses are all in our office, whether it's in New York City or Albany, and you're in the comfort of your own home, and we can do the document signings that way. If you can't make it to the office, of course, we would prefer to see you mask to mask, or someday face-to-face again in the office. That's still the primary way that we do our document signings. So Peter, the question, why now? Who will make decisions if we're not able to make them for ourselves is a question that we all have to grapple with.
That's true. And you know, people say, well, it's not going to happen to me. And, you know, is this just for older people? And the answer is no. And, you know, the term life happens and maybe the happenings aren't so good is really important. And it's also true with younger people. If you're in your 40s or younger and you're recently married or have young children, stuff that ain't so good could happen to you too. I mean, I hate to say it, but over the last couple of years, I've had a couple of people in their late 20s, you know, who drove their motorbikes under a bus or a truck, or they could have serious illnesses. There may be psychiatric issues. You've got to plan now, and planning doesn't mean you're signing a piece of paper. You are keeping control over your lives so that you set the rules for your future decisions if you cannot make them for yourselves. And you appoint the people that you trust to honor your wishes and not leave it to the default of a guardianship proceeding. And this is what we're going to talk about this morning. But the default, if you don't have these documents in place, if you haven't done the planning for making decisions about your finances and your health care, and you wind up in a guardianship court, you could wind up with a stranger managing your life. And this is what this is all about, taking control and preserving your autonomy.
And we start now at much younger ages than we used to. And I've had a lot of clients. I was one. Your children go off to college. They go to the health center. You want to find out how they are. So you call the health center, and the health center says, well, we don't have any medical authorization on file. So we're sorry, but we can't even let you know if your child is in the health center. So very often what we're doing now for people 18 and above who are going off to school is doing a healthcare proxy and a power of attorney so that parents have the ability to gain access to information. And if their child does fall into a situation where they need decisions made, they have that legal authority because the parental authority ends at age 18. So having legal authority for those areas when your children are away is extremely important. And of course, you want the power of attorney, Peter, so that when they run out of money, you can actually go deposit money into their bank account and use your power of attorney to access their account to put money in. So those are very, very important things to think about if you do have children in that college age and beyond. So when do you start doing this planning? Truly, for many people now, it's age 18, getting the basic documents in place. We're going to talk about healthcare decision making. One of the premier cases was the case of Terry Schiavo. And Terry Schiavo was a young woman in the state of Florida who went in for a routine surgery. And this is another item, Peter, where life happens. She went into for routine surgery and came out of the surgery in a coma and never recovered from that coma. 9 years later, there was a court proceeding which went through multiple courts. 19 judges ruled on the case as to whether or not they were entitled to remove artificial life support. And they did remove life support. But how old was Terry Schiavo when that case started, when she had a routine medical procedure? 22. Right. So it happens at younger ages. We also want to plan to protect assets, provide a legacy to secure your family's future, and ensure that your property ultimately gets to the people that you choose in the way that benefits them the most. So you mentioned...
Going back to the Terry Schiavo case, it really illustrates the importance of having these documents. Why did it take 9 years for the husband's statement that she wouldn't have wanted to be sustained in that comatose state for another 20 years? Why did it take 9 years? Because she didn't have written documents, and that would have made a very big difference. So the message of the Schiavo case is you can prevent a lot of these happenings and make sure the physicians follow your wishes. And it's much better to do it in writing, as well as having those conversations with your close, trusted family advisors.
And as you mentioned, Peter, the result of not having the documents in place is that someone has to go petition a court, petition a judge to be appointed as your legal guardian. And that could be guardian of the property or guardian of the person to make medical decisions for you. That guardianship proceeding, we do a tremendous amount of guardianship work in our office. It's probably the least favorite thing that we do because it's running people through a court process that is totally unnecessary. And it's litigated. And in many cases, if it's property that's at stake, there are multiple family members who are arguing over control of that individual and their property. Sometimes I've litigated a case that went 7 trial days with a family that had enough money to litigate that case, but it was over their father's care and where he would be cared for and how he would be cared for. This can all be obviated. It can be done away with if you have the proper documents in place. So
right. And one of the biggest problems with the guardianship in the case that Lou discussed, where the family members are fighting about what is the right decision, is the court is likely to appoint some lawyer or social worker on a list of qualified guardians, and you won't know that person, and you have no control about what that person's decisions will be about your life. So you're as you see in one of these bullets on this slide, you lose autonomy, you lose control. And, you know, Lou and I might be on that list, and we're pretty busy. And, you know, we may not get to the hospital to be able to help make the decisions as promptly as your trusted family person might be.
Yeah.
Although we promise to do so.
And we're going to talk about how you do the documents. Keep yourself out of court, keep your family out of court. You never want to be in a litigation position. During your lifetime, guardianship court, which is in New York State in the Supreme Court, is where you go to try to solve problems for people who lose capacity and don't have planning done. Expensive, public, just not a very fun time for the entire family. Who wins in these cases, Peter? Lawyers, because you have multiple attorneys, some appointed by the court, some representing various parties, all running their meter on your dime. And you never want to be in that situation. The other place where you want to avoid court is upon your passing. You don't want to ever have to go through the probate process. And Peter, the pandemic, especially in New York City, has really impacted these courts.
Well, first of all, in general, we like you to, the phrase is avoid probate, and we'll talk a little more about why. But even in the event that, you know, the courts are open, there are terrible delays, right? And in fact, for the last year, the surrogates court was pretty much closed down, and you know, there was nothing you could do. So if you didn't have a trust, which we're going to talk about in a minute, and your assets passed to your descendants through the will, and there weren't any joint bank accounts for the wife to have access to funds, the spouse, the wife or the husband may be unable to access money because the courts were closed. And now that they're open, there's a 3 to 4 month backlog. So go ahead, Lou.
Avoiding the courts at all costs is proper planning. So how do we do it? How do we get to the place where we have the right documents? Today, we're going to talk about avoiding the guardianship part of this. Wills, every will by definition, regardless of what you've been told or what you've read, every will by definition requires that it go through the court process called probate. That's the definition of probate, the proving of the will. So when you have a will, it may be all well and good. You have an executor, you have beneficiaries, but that executor has to petition the court, serve all the right parties. And we've had probate estates in our office go on for 10 years. Most of them are done within 1 to 2 years, but it's going to be a time period that you have to hold the estate open. Before you can even get to assets, you have to get letters testamentary from the judge. So as Peter said, that's not where you want to be. But we're going to talk about these 4 documents, which comprise a core estate plan, things that everybody should have in place. Very easy to do, but you want to make sure you do it with the right people, and that people that have experience and can see problems before they happen, so that your documents are designed to avoid all of the pitfalls. The power of attorney, the healthcare proxy, the disposition of remains appointment, and the will are our core 4 estate planning documents. And the power of attorney, Peter, is one. We see people without them. We also see people that have them, but not properly drafted.
Correct. So essentially, for those who aren't familiar with the form, a power of attorney is where you delegate authority to a trusted person to make financial decisions for you. And that document is effective if it's properly executed upon signature. And if you're not happy about the fact that someone has the right to manage your affairs, even though you can do it for yourself, we have something in New York called a springing power of attorney, one that only becomes effective if your physician or two physicians or committee that if you're very nervous about this, of 10 priests, 14 ministers, and 5 rabbis can certify that you can't function on your own. It's a joke, but you can see where this goes. So springing power is really a protective device for those people who are nervous about giving up control. And therefore that power of attorney can't be used until you've been determined to lack capacity to manage your own affairs. But it's limited to property. In New York, the power of attorney does not allow your agent, your representative, to make healthcare decisions. That's the healthcare proxy, which we'll discuss in a minute. And again, the execution, a proper execution of the power of attorney means you don't really need a property guardian, because you've established a system to do what you can't do without the default guardianship proceeding.
2 other points just to make on that. One way that you can hedge your bet is you can appoint multiple agents. So if you want to make sure that there's oversight, you can appoint co-agents under the power of attorney and require that they act in unison or jointly. You can allow them to act separately. That's the more convenient way to do it. So there is flexibility in the design of the document. The other is that you can appoint a monitor in the current power of attorney form, and that's someone who could oversee it, perhaps your accountant, to make sure the bills are getting paid properly. That's another option. And finally, you want to make sure that if you're doing this for estate planning purposes, which is virtually all we do, you're going to have a statutory gifts rider on the power of attorney with powers to make gifts and create trusts, so that for tax planning and asset protection, your agent will have the ability to carry out all of those functions on your behalf. So that's the financial side of this. Peter, let's turn over now to the healthcare decision-making document.
So the document in New York called the healthcare proxy, where you appoint a representative, a surrogate, so to speak, to make healthcare decisions, called your healthcare agent, deals with the property. It's in a sense a healthcare power of attorney. We don't call it that. It's a healthcare proxy. And this is a critical document. You appoint an agent, and you can only have one healthcare agent to act at any particular time. The law very wisely says we don't want the 2 children in the emergency room fighting over whether the answer is to do the procedure or not do the procedure. And this is very critical, obviously, towards the end of life, where these decisions may involve whether you're going to live or you may die from this illness. So that brings us to the responsibility of this agent. The agent's responsibility is to act in accordance with the wishes that you, as the maker of the healthcare proxy, has explained to them, both in oral discussions and in the document commonly known as the living will, which we prefer to call a healthcare declaration, because that's what it is. It's not a living will, it's really maybe about your dying. And we like the term healthcare declaration. So that document, which goes along with the proxy, is the evidence of your wishes, and your agent is supposed to be carrying out your wishes. If it's not clear what your wishes are, the agent does have the right to make a decision that's in your best interests, that you make a rational judgment after talking to the physicians and your social workers, whatever the situation may require. The agent can then make a best interest decisions. But first, it's to act in accordance with your wishes. And that's why the choice of who you pick as your agent becomes critical to this process. It may not be my daughter, the doctor, because your daughter, the doctor, may decide what she thinks is best for you. It's the person who has the emotional and psychological ability to make the decision that you have chosen, even if you don't agree with it.
And the question comes up, Peter, when can you do these things? When are you too incapacitated? And that's a question that a lot of people get wrong. because different documents have different standards of capacity required for their execution. And the healthcare proxy has been ruled by the courts to be one of the lowest levels actually, of capacity required. So you've litigated this issue, Peter, in guardianship courts over the years, and you teach guardianship at New York Law School. How do you draw this capacity line, and when are people able to sign documents?
It's a complicated question, and of course we have limited time today, but you're absolutely right. The old way of looking at capacity was it was like an on-off switch. You either had capacity to take an action or you didn't. That's no longer true. Modern theory about this is that capacity fluctuates, as Lou said, depending on the particular task. So signing a healthcare proxy requires enough capacity to know that you may have difficulty making decisions in the future, that the person that you're choosing to make those decisions for you has some significance and meaningful relationship to your life. It's a logical person to pick, that the decisions that you're instructing the person to do, you understand the implications of the fact that they may be making decisions for you. The higher the task, so for example, in a healthcare proxy, that's pretty much the same in a power of attorney, that's pretty much the same standard. If you think you're having difficulty making decisions about your financial management, you appoint an agent. That's pretty basic, but the standard of understanding needed, if you put on a gift writer, if you're giving that agent the ability to move money from your name to himself or herself or to a trust, that's a more complicated, more sophisticated level of understanding. So now you may need more capacity to sign a proxy or a power of attorney if you're doing more complicated decision making. So it's individual, and we've developed a set of guidelines for you to help you to decide whether you can do this. And we don't have time to go into it today, but you can call us or write to us, and we'll send you those guidelines and more about all of these subjects.
So we have designed very specific language in our documents over the years, and Peter and I have collaborated on drafting the power of attorney and the healthcare proxy to be working in sync. Those are proprietary sets of documents in our office. We're happy to make them available to our clients. We have also put together, under Peter's direction, a guide to healthcare decision-making that talks not only about the healthcare proxy and the healthcare declaration, but also the MOLST, or medical order for life-sustaining treatment, the do not resuscitate order, and the nuances among all of these documents. We'd be happy to make that guide available to you. And all you have to do is email us, info@pierrolaw.com, if you'd like to get our healthcare decision-making guide. So Peter, those are advanced directives that cover us during lifetime. Upon death, the question becomes, what happens to my corpus, my body, and what happens to my property? And for many years, the body issue was not addressed in the law, but several years ago, about 15, New York enacted a statute that allows us now to appoint an agent for this purpose as well.
And it's a very important document. You know, just as you don't want your children fighting in the emergency room about whether to do a particular bit of surgery or not, you don't want your children sitting at the desk of the funeral director arguing about where you're going to be buried. Oh no, mom wanted to be buried with her family out in Brooklyn. And the other child says, oh no, dad wanted to be cremated and his ashes, thrown off the top of Mount Everest. We don't want those fights. So you choose again the person you think will carry out your wishes, and you can express your wishes. If you want to be cremated, you can say that in the document, and that will eliminate this kind of very emotional and unpleasant fight after you die.
And when many clients come in for their first consultation, we start talking about the documents, healthcare proxy, power of attorney, will, and they've heard of those. Most clients haven't heard of a disposition, a remains appointment. Most attorneys don't do them. I've been doing them now for 15 years. So literally every estate plan that we've done for 15 years has included this document. So I've talked to thousands of people about their final wishes, and I can't tell you about them all, but some people are very creative. In cremation has opened up a whole new window of what can happen to your ashes after you are cremated. All of that goes right into the document, along with your church service, your funeral home, your cemetery, choices that you have. If you don't have those choices, then your agent would make those for you. But I agree, this has avoided a lot of litigation upon the death of an individual. And some of those cases, I won't go into them all, have really spawned litigation that's going on for years. And they've kept people frozen, like Ted Williams, who's in a laboratory in Arizona, cryogenically frozen. Did he ever want to be there? Probably not, but that's where he ended up. Long story, but let's move on to the will, Peter, because this is a vital document. And here's where we're going to deal with the property issues. And you have to be careful because some assets like IRAs, 401ks, annuities, they have beneficiary designations that are going to take them to owners outside of the will. So those things are not through the will, through probate. They go directly to beneficiaries. But for your probate assets, your home, your other accounts that don't have beneficiaries, the will dispose of that property. You want to make sure you're giving careful consideration to who the executor is. And again, you can have co-executors here. You can have them act jointly to make sure that they're collaborating and coordinating your estate administration. You have multiple children, they can all be part of this. We try to keep it to 2, maybe 3 at the most, very seldom more than 3. But the executor is the one who is going to hire the lawyer, petition the court, go through that whole court process, collect the assets, marshal the assets through the court, through the estate, and then make ultimate distributions. You're going to choose your beneficiaries, and this can be spouses, children, others, charities. You want to structure that properly. If you have minor children or disabled children, you can create trusts for them under the will. They're called testamentary trusts. But those trusts, again, are under court supervision and will be guided by the judge throughout the term of that trust. You can create other interests for tax planning purposes. We can do some estate tax planning under the will. All of that happens traditionally under a will. If you have minor children, you also want to make sure that you appoint a guardian. So the guardian is someone who will take charge of them and care of them until they're 18. And again, at 18, they're emancipated in New York State and they become adults, and no one has legal control over them once they turn 18. So the will, again, a vital document, but a probate document. Peter, your thoughts?
But, and it's a big but, all the things that you could do in a will, you can do in a trust. The problem is that the will has the delays of the probate proceeding and ongoing court supervision, particularly when you have trusts for minors. That's why we always discuss with clients, and for many people, or probably most people, the living trust makes sense because that becomes the real will. But it has another big advantage. If you become ill in later life, the living trust is the best management system to care for your property and manage your property and make your investments and provide for you. And it's far more efficient than the power of attorney, as good as the power of attorney is, particularly with the new law coming into effect on June 13th, where there will be some improvements and a few disadvantages. But the living trust is your best asset management to maintain your independence and autonomy during your lifetime. And upon your death, there's no delay in the continuing administration for your spouse, for the children that you've created ongoing trust for, and for the ultimate disposition of your estate.
So we refer to the living trust as the Swiss Army knife of estate planning. It can be used for multiple purposes. And if you want to learn more about trusts, please join us for our next webinar, which is 12 o'clock to 12:30, same as today, but Tuesday, May 11th. We'll be covering the living trust and how you can utilize this vital tool to make your estate plan work for yourself and ultimately for your beneficiary. So Peter, when should people start thinking about estate plan?
Yesterday.
My glib remark when people say, well, when should I do a will is, tell me the day you're going to die. I'll have you come in the day before. We'll be very efficient. We'll get it done right on time. But nobody has that crystal ball. So
nobody does. And when the clients ask us, what should we do? But now that we've told you all our problems, I say, your crystal ball is better than mine. And that's the problem. So we turn to our clients to make decisions. Our view as attorneys is to be your counselors, your advisors, give you options, give you recommendations, but we believe you can decide and should be making those decisions.
And we're happy to provide you with a free consultation. We like to have an estate planning questionnaire done prior to that consultation, which we will make available to you. And you can schedule in our New York City office, our Albany office, and we have multiple offices throughout New York State. So we can be convenient to you pretty much in any location that you have, and not west of Utica. So if you're from west of Utica, we'll arrange something out there. But info@pierolaw.com if you'd like to schedule a consultation with us or just get the information and the questionnaire, you can certainly inquire that way. And there's a list of all of our other offices there on screen. With that, I'm going to turn it over to Peter, and I'm going to give him the last word, which is unusual for me.
Well, that is, Lou, and I appreciate it. We care about our clients. We're concerned about what's happening in the world around us, and we really do believe that we can help you. We've been doing it a long time. Lou and I have a combined years of expertise that's probably about 100, which is a nice number. And we'd like to think that we can use that experience to solve your problem. Every one of you is different, and we will listen, and we will hopefully solve any future problems that you may have as best we can.
Thank you.
Have a
And
great day.
we hope that you can join us on the 11th of May at noon for trust planning. Thanks very much.